I wanted to touch upon a few aspects with regard to the importance of wills and what are the myths around wills and estate planning. Can I have the first slide?
Yes, yes,
Uh, a lot of people have this tendency of saying, uh, I do not have much assets to bequeath. I've got just a few a house in a cooperative society, a few mutual funds, some fixed deposits, an insurance policy. My family is small. I mean, I do not have too much of assets to bequeath. I have nominations in place. As Himanshi rightly pointed out, people have the aspect that nominations are like trustees. I mean, are trustees. People think that if I have had nominations in place, I do not need to make a will. Nominations will take care of my loved ones. But that's not true, as nominees are only trustees and are trustees for and on behalf of the legal heirs. Another issue that people have in mind is my family is united. Everything will go peacefully after my lifetime. There will be no fights. There will be no disputes, things like that. But I have seen cases where, as long as the parents are alive, siblings are very close. There are no misunderstandings. And as soon as both the parents pass away, disputes arise. Another thing to note is people put off writing a will. They put off writing a will saying, I'll do it when I'm retired, or I still have time to make my will, or writing a will is such a hassle. I have to dig into all my papers and investments and things like that. Some others feel if I write my will, or if I talk to my wife about writing my will, she'll be upset. Or if I talk to my people about writing it, they'll be upset. So a lot of people avoid writing the will. Some people feel that if I write my will, something will happen to me, so they postpone writing their will. These are all myths, these are all misnomers, and people do not understand that by writing your will, you are on the contrary protecting your loved ones, and you will have peace of mind while writing it. You will get clarity of thought as to what you want to give, to whom you want of your properties. As Himanshi pointed out, that if you do not make your will, it will be the personal law which will take over and not your own personal wish. Okay. The next slide, please.
yes,
Uh,
yes.
while about estate planning, you have when you're writing a will, you have a choice whether you want to give portion of your property to your loved ones, whether you want to give some property to charity, whether you want to give a portion of your property to somebody who's helped you, or something to a friend in token of appreciation. Today, will writing is the most tax efficient because there is no estate duty. So it is the most tax efficient tool of transmitting wealth to your loved ones. It's flexible because you can write it the way you want to. You can put down to paper what are your desires. You can seamlessly transmit your assets. By appointing executors, you will give them the guidance as to how the assets, who will be the executors, and how the assets will be transmitted to loved ones. Where if there is anything relating to succession, especially where you have assets which involve, let us say, business, etc., you will be providing clarity to that aspect. Mitigation of family disputes. Having a will in place and having a will written in a manner that leaves assets in a manner that there is no dispute between people will go a long way. Not that a will cannot be challenged. A will can be challenged, but the manner in which one writes his will is most important. And as I said earlier, there's clarity of, there's peace of mind that you know that if something happens to you, your assets will get transmitted seamlessly to your loved ones. Of course, this has already been dealt with by Himanshi, but I wanted to focus on a few aspects of it. That suppose you have children who are in the minority, you would not like to leave the entire wealth to them when they are minors. So, by writing your will in a manner that you appoint guardians for them, to hold the assets in trust for them, to give them the wealth at certain ages, say at the age of 18, 25 and like, is something that will help to prevent wastage of your assets. The assets which you have won over a lifetime, you don't want it frittered away by your children. There may be parents who may have special children and they would like them to be looked after in a particular manner. So appointing a guardian through the will and seeing as to how the assets can be used for the benefit of that child could be of importance. And as I said, the way one writes his will, Himanshi spoke about the fact that you can also write in specifically if you want to disinherit somebody or the circumstances under which you are bequeathing your assets to one person to the exclusion of another person can be done. How do you prevent disputes with regard to your will? Appointing the right people as executors will go a long way in mitigating disputes. Some people go to the extent of appointing independent people as executors. You may appoint your lawyer, you may appoint your chartered accountant, you may appoint a family friend, somebody who can be respected by the family. This depends on your family dynamics and what are the assets you have. So appointing the right executor is of importance. The second aspect is choosing the right people to be witnesses. We would not like to appoint somebody who cannot stand as a witness in case the will is to be contested. So choosing the right witnesses, somebody who is young enough, somebody who has got a credibility and who can, stand in a court of law in case the will is challenged, is important to decide who the witnesses are going to be. So definitely you would not like to have somebody who is a temporary employee or a maid or a driver or somebody like that. You would like to have somebody of some credibility to be the witnesses. Maybe could be a good person to be a witness. Writing a will also requires you to know as to what you're going to bequeath to whom. So that would depend on what your family dynamics are and what are the assets you want to bequeath to whom at what point in time. Registration versus non-registration. Often there is a dilemma as to whether you need to register the will or not. People who are senior citizens and of advanced age, it is preferable that they register their wills, and not that a registered will cannot be challenged. A son might pressurize his father to write a will bequeathing everything to him and register that will. That will is not a free will and can always be challenged. So the circumstances under which the will is made can be challenged. So while registration is preferable, especially when there is land as property or the properties are complex, to have some sort of credibility over the will, registration is advisable. Some people also do videography when the person is, executing his will as proof of the fact that he is, in his right mind and he has executed the will. But it is not compulsory or to, do videography. Medical certificates. If a person is of a senior citizen age, it is preferable to have a medical certificate to show that he is of a mentally sound and medically fit to make his will. And there are at times people put prohibitions in the will, saying if my will is challenged, that person who contests this will may lose the bequest under the will. But this is something which is so far not been tested in a manner in courts. But this is just to ensure that the will is respected by the legatees. And another aspect which needs to be looked at when you should make a will, any time is a good time to make a will. But particularly if a person changes or if he divorces or remarries, he should make his will. When he gets children, or if a person is having some, apprehensions, he needs to change his will. But when you should not make a will, when a person is of seemingly mental incapacity, that is the time when the will can be challenged. So the time when making the will is when you are in absolutely free mind of making your will, and not when a person is of a very, very advanced stage. Yeah. And yeah, that's it.
Yeah.
So
So
these are the aspects which will allow you to make a will in a manner which limits the disputes to your will.